The legal impact resulting from labeling student athletes as employees. There have been a lot of eyes of the National Collegiate Athletic Association (NCAA) as newly implemented laws are poised to change the perception of collegiate sport. In 2021, in National Collegiate Athletic Association v. Alston, the Supreme Court held that college athletes would no longer be restricted from benefiting from their name, image, and likeness. Thus, Alston opened up the right for student athletes to profit from sponsorship and the ability to team up with companies eager to have collegiate athletes promote their brand. NCAA Alston argument and the result of its failure. In Alston, the NCAA argued that allowing college students to benefit from their name, image, and likeness would take away the separation between the student and professional athlete. Essentially, any change allowing them to be paid would take the amateur status away from the players and team. Nonetheless, the NCAA argument didn't stand, and the Supreme Court established the opportunity for collegiate athletes to profit. Now, well into college football season and the start of basketball season, college stars are signing with agencies and beginning to see the profit their universities have been benefiting from for years. In addition to the team goals of winning championship and individual goals, both players and coaches now have agencies and sponsorship to navigate through the first time. However, with this new potential for earning comes question on the legal status of this student athlete. NLRP addresses proper label for student athlete. On September 29, the National Labor Relations Board (NLRB) issued a memo that will shift how college athletes are classified. In her memo, General Counsel for the NLRB, Jennifer Abruzzo, addressed the public with a statement that college athletes are considered employees under the National Labor Relations Act (NLRA) and are entitled to the full protection available to employees. The assertion made by Abruzzo provide legal advice and standard to guide future events if and when a case with the NLRB does arise. Specifically, labeling collegiate athletes as student athletes rather than employees will be considered a violation. Furthermore, General Counsel stated the freedom to engage in far-reaching and lucrative business enterprises makes players at academic institutions much more similar to professional athletes who are employed by a team to play a sport. Collegiate athletes have always been participants in lucrative business enterprises. However, before Alston, they didn't see the profit made by those business enterprises. Their universities and the NCAA profited instead. While not every student will see an influx of cash, the top athletes in the largest and most successful program are anticipated to make approximately $2 million each year. Statutory protection of the NLRA awarded to employees. In 2015, the National Labor Relations Board dismissed a case brought by a group of NCAA football players at Northwestern, thereby declining to characterize student athletes as employees under the National Labor Relations Act. Now, 6 years later, this newly released legal memorandum by the NLRB deviated from the precedent. With employee status, this athlete would fall under all statutory protection provided by the NLRA. Various other statutory protections include the right to strike and the right of employees to choose their representative. In addition, the NLRA provides protection for protected concerted activity, which include the option for employees to come together and protest the term of their employment. Therefore, this provision opens the door to potential collective bargaining agreement for players. Specifically, athletes at these universities will have the option to collectively bargain and negotiate for better working conditions without fearing retaliation by the school or the NCAA. NCAA respond to the characterization of college athletes as employees. The NCAA released a statement that it would like college students to not be considered employees but rather continue to be labeled student athletes. It wants to prevent the university student from being afforded all of this statutory protection, including unionization. However, if the NCAA look at previous cases banning player union that it considered successful, the organization may realize that one was successful may no longer be legal. Thank you.